Great. And then as a follow-up, maybe we're looking at this wrong, because I think many of the questions come from a bit of a confusion as to, well, if we can't define what merit is and we don't have a dollar target of what we're trying to cut, how are we going to judge if this is a success or not? So maybe you could articulate it in a different way, which is the goal of the reorganization to ensure that the state of California, even more importantly than saving $5 million, which is a wonderful thing, but in the grand scheme of things is a drop in the bucket, isn't the goal here to ensure that the best and the brightest are hired for the state of California and remain in their jobs, and as a result the state reaps untold millions in that efficiency and in that effectiveness?
Sure, absolutely.
That's it. That's all I get from you. Sure, absolutely. The reason I say it is because, let me give you another chance. Mr. Talkative suddenly goes quiet. It's unbelievable. I'm concerned that we get lost in the weeds of if you can't put a dollar figure on it, it's not a good idea. And if you can't define what merit is, then this is sort of just putting two bad products into a larger bottle that saves space, maybe, but doesn't make for a better product.
All right. So you've heard how the SPB has already made great strides to speed hiring up, and the merger of our departments is only going to accelerate that. In addition, out in the what do they call it, line departments, line agencies, people are going to be able to make their promotions quicker, get answers to, we'd like to merge these classifications, or we think we need a new classification. And right now, they've got to go to DPA in my shop, and we say, okay, whereupon it gets shipped over to the SPB, and it's just an incredible delay. And it's waste all the way around, and I think it's bad for morale. It's bad for department heads or high managers who want to promote people, for departments that want to hire people, et cetera. So we are definitely going to save bucks. I mean, we've got defined targets. Finance has given those to us in terms of PY, and and they'll be back on us if you folks aren't. So we do have money savings goals, but really the idea is also to help morale and indeed to get the best and the brightest that we can possibly afford and promote them and so on and so forth. So I agree with what you say, and I'm trying, I guess, to convey by the fact that both our shops are committed to it.
Commissioner Bradshaw?
Can I just clarify something? Because I think two commissioners didn't hear part of it, so I want to make sure I heard it correctly. I thought there are budget targets, because finance testified to exactly what they are, and that they're over 2 years, not 1 year, which is more realistic because you're not going to get savings in this year. It's over a 2-year period, and that finance felt that they, in fact, were realistic, not pie in the sky. So I don't want people to think that there weren't budget targets, because my understanding is there were, unless I misunderstood.
No, it's in the letter. There are budget targets in the letter. I think that there are some things that are left open. It's when we were having the conversation with Ms. Ambrose about, how many positions you need. I think it muddies the water about whether you can actually achieve the targets if some of that's open. But there are targets, and there are definite targets in the letter.
Mm-hmm. Right. So anything less than what they believe is, in fact, going to be additional savings.
Yes.
Commissioner Schwartz?
And I can guarantee you finance will hold them to the PYs.
From my perspective, the question isn't whether training is done to address and educate people in things like avoiding gender bias in the workplace. Of course it should be done. Our firm has to do it. The private sector is expected to do it, and I would hope that the state would do it too. That's not the issue. The issue is the repeated complaint by this commission over the last 20 years that you have ossified and redundant functions that cross between various agencies. So we've got now 3 here. And so maybe the way to figure this out is to ask the question of Ms. Ambrose, of those, first, I never got a specific answer. How many new complaints were filed with the SBP in the last 12 months?
You mean discrimination complaints?
Yeah, well,
Oh,
all,
okay.
and then within that, I'm going to get to that. How many?
So discrimination complaints, there were about, I think, 96 last year.
Okay, and all in, over the last, for calendar year 2011, how many complaints were filed? 96?
Calendar year 2011?
Excuse me, 2010.
10,
Yeah.
96.
96, all in.
Discrimination complaints.
Okay. Now, if you are a disgruntled employee who has a complaint, one of the 96, she or he could also, I think, file with Ms. Chang's organization,
Yes.
correct?
Yes.
Or that he or she could file with the EEOC,
Yes.
right? And maybe there's a third or fourth venue that they could bring a complaint to. I don't know. Am I missing?
Court.
Or court. So, and if I were to bring my complaint to you, your division, and it goes through this process, and hopefully it takes, 6 months if we're lucky to get it processed, maybe. And I get an adverse determination, I get a ruling against me. Can I then reinitiate a process with Ms. Chang's organization?
Simultaneously.
Right. And I could also go to the EEOC. Or
Yes.
is there, so that's
That's
the
not
problem.
different- That's not any different than the private sector. You can file a complaint with your employer and file a complaint with the Department of Fair Employment and Housing.
The difference is that we're trying to streamline because we can and we have the gubernatorial authority to reorganize. So unlike the private sector, which can't change the structure of these various departments, we hopefully can. And so then the question is, with all this backlog that I think your general counsel described was in 3 years ago a nightmare, maybe one way to approach the problem is to figure out who amongst these 3 or 4 organizations ought to take the lead. And
But that's what we've done.
Yeah.
I mean,
what I hear is that there is still the possibility that the complaints could be brought to the newly created department as well as FEH.
Oh, I'm sorry.
no.
No.
Here's the only way that could happen. I'm being discriminated against because of my gender or whatever. Those are going to go to DFEH. The only way the board, I think, would keep it is I didn't get this promotion because of my ethnicity.
But respectfully, you still have 2 separate venues to raise the same.
All right,
complaint.
but that narrows it. Not that many cases involve failure to get promoted. Most of them, have to do with a bad transfer, or I'm not getting paid enough, or my travel allowances are, I've got the wrong cubicle, and it's all because of my race. The SPB had to hear those before, and it won't afterwards.
Ms. Chang, you want to weigh in on this discussion?
Yes. Thank you for inviting me to testify. The Department of Fair Employment and Housing is the state civil rights agency, and we're the largest state civil rights agency of its type in the United States. We actually take in, together with the EEOC, all of the employment discrimination complaints in California. Between 2008 and 2010, our department took in 54,801 complaints of discrimination. Of that, 1,346 are state employee complaints. So that's about 2.45%, a very insignificant, actually, given the entire scope of the types of complaints we receive. Some 96 or let's say 100 complaints that were filed with SPB. I'm not sure, but I would imagine that many of them, if not all of them, were also dual filed with us. That would comprise about 0.5% of all the discrimination complaints that my department receives, investigates, conciliates, mediates, or prosecutes. So in terms of the reorganization plan of the governor, we are completely in support of it. We believe that it's good for state departments to have a streamlined process. of the type that's being proposed. So we are completely in support of it. In terms of taking over the responsibility of the SPB to hear civil rights cases on behalf of state employees, we already do that, so it's really a duplicated function right now. It would not be a burden to us. 100 cases would be actually very insignificant because we probably already get them. So we're fully capable of taking on that responsibility, and we don't need any additional resources for doing so. I don't think that the civil rights protections for state employees will suffer in any manner at all. In fact, I think it could be more speedily resolved because you wouldn't have the possibility of perhaps two conflicting results. And anybody who wants to take their case to court, whether or not they file with the SPB first or with us, would still need to get a right to sue notice from my department. So no matter what, they still have to come back to the department, or if it's dual file with the EEOC, they can also get that right to sue from the EEOC. However, we actually investigate 75% of all the California employment discrimination cases, whereas the EEOC only takes care of 25%. So we really are the clearinghouse for this kind of work. We're very happy to take on the responsibility. We are very happy to continue partnering with DPA and SPB to conduct training. AB 1825 sexual harassment training is something that we do anyway. And in fact, these are two slides from the PowerPoint presentation that we're going to be presenting, that one of our staff council would be presenting to about 30,000 state managers and supervisors free of charge.
I think I read your letter, and I thought you did a good job of laying some things out, and you just made a comment that, again, I think underscores for me why this is. I'm absolutely amazed that it's taken this long to get to this point, because you're talking about doing sexual harassment training. You're already doing sexual harassment training, and I think the question because I made a note of this in the back material is I was confused by the appeals of discrimination in state employment, and then the hearing on merit system appeals that deal with selection and appointment. So just under this scenario, someone files a complaint because they believe they are passed over for promotion or for hire based on the color of their skin. Today that goes where, and under the new proposed system it would go where?
Today it comes primarily to my department.
Primarily.
But a few, maybe a handful, 100 or so, might also file before the SPB.
Okay.
But in the future, all of them would come to us, but I think we already capture them. So it's just
I just want to make sure I was clear on that. Is that you are getting rid of the two entry points? There will be one entry point which will come through you, because you just made another statement which is correct. Today there's a possibility of two conflicting outcomes.
Correct.
Now, one outcome through you.
Correct.
Okay.
And if I can just clarify, the thing that will stay with SPB is where there's been a disciplinary action brought against an employee. The employee appeals it to us, and as part of their defense, they claim this discipline was brought against me not because I'm incompetent, but because of my race. And they can also then file.
Okay, so whether it's discipline or hire, why would that not go through you, Mrs. Chang? I don't get why that would.
That one could go both places still under the new system.
Okay, so I don't get. So if I don't get promoted, or I don't get a job and I'm making the claim that it's because of the color of my skin, it goes through you.
Right.
But if I'm disciplined and I'm making the claim because of the color of my skin,
right,
it goes through you.
It goes through us, and they can also file
again. Why would you have a dual process for that?
Because our focus is the discipline and whether the discipline was for a valid reason.
This goes back to your counsel to the board on whether.
Is that part of your constitutional mandate?
Yes.
Really?
It's spelled out specifically in the Constitution.
Okay. So the civil service system that all state employees and bargaining units are under, that this process only changes well, no, I guess, how does that, now I'm a little confused. Okay. You're mandated to do that one aspect as it relates to just the word, the discipline.
Discipline, yeah.
Everything else can go to Mrs. Chang. Okay.
We could recommend they change that, though.
Yeah, I mean, that's,
Commissioner Bradshaw?
So if somebody appeals somebody has an action before the board, and then there is a disciplinary action that they're alleging is a result of their filing an appeal to something, that's what you're holding? I guess I'm trying to figure out why it can't go where everything else goes.
that's what constitutional mandate.
Right. If there's discipline involved, if the employee's been disciplined, demoted, okay, for misusing state funds.
Right, that would go to you.
That would go to us. The employee, though, says in the hearing, no, the real reason I was disciplined is because of my race.
Okay, so there's only one action.
One action. Exactly.
One. So
Yes.
it's not. They're saying it's not a retaliatory action that they're also stays with you. And I'm taking apart the equipment here.
Right. They're claiming retaliation.
And
It's their
you
defense.
have,
But there's not. It's in the process of a single action. That's their defense
Right.
to an action. It's
Right.
not. They have filed a second action.
Right.
but they have the possibility of getting two different opinions.
Yeah. I think in that situation they could, because they could also file with the FEH, have an investigation done.
So why wouldn't you just set up, you could only file the FEH as an appeal if they didn't like your action? You're saying they could file simultaneously.
Correct.
Or provide them with an election of remedies. In other words,
I don't get why we think that should be normal and appropriate.
I understand that
I
would
understand.
take statutory change.
No,
Yes.
I understand why it might have to start with you, but having it start at the same time with both, that's not statutory. That's not statutory. That's just a policy change. You can file with you. If they don't like what they hear from you, then they might have the appeal process here, but that's not required by statute that it goes.
No, there's you can speak for yourself, but they've got to file then what, 6 months?
A year.
1 year.
1 year with the FEH. And right now they can file anytime they want while they're doing this. It's
I know, but that's not in statute.
Yes.
That's in statute. They have to
Yeah.
file within 1 year.
1 year.
yes.
1 year of the action of the
Yes.
proposed.
The
Under
address.
the Fair Employment and Housing Act.
Yeah, but you're not taking that long to make a decision.
Well, right. But we could. I mean, it's theoretically
Obviously,
you could.
I'm wrong
We used to.
based on the response from the audience.
And certainly,
Yeah, based on the I'm wrong.
and certainly, I mean, there are occasions when cases go beyond the 6 months. I mean, the parties have
I guess
scheduling issues.
I would think that we're all on the same page, that it doesn't necessarily make sense that you're making a dramatic change and having everything go through you. But in this instance, you are retaining the same process. And as Commissioner Schwartz said, I don't know why we wouldn't look to.
Our focus are two different things, okay? DFEH's focus is whether or not somebody's civil rights have been violated. Our focus is whether or not there's been a violation of this person's property right, property interest in their job. DFEH has different remedies than SPB does. They have greater remedial authority for a victim of discrimination than SPB does. Our remedy under our scheme for an employee who wins their disciplinary appeal is that they get, put back to where they were and back pay.
But they have the same. You said they have a bigger toolbox than you do, so they would have the exact same thing, right?
Chinese face.
We have that, plus we would have other,
Yeah. So
other remedies.
again, so
other
you make my
damages.
argument. I mean, if they have a bigger toolbox and more remedies.
But the remedies we give, okay, so we put the person back to their job, we give them back pay. That they don't then get it again.
No,
with
I'm not
the
saying
FEA.
that, but I'm saying they can also give back pay and
Right.
whatever. It just doesn't make it doesn't.
It's in the-
I'm confused about
It's
something.
in the Constitution.
I'm going to be. Do you ever disagree? Do you win? Do you lose? Do you lose? Do you win? I have to understand this. I mean,
Yeah. We don't really do that many cases, quite frankly. I mean, we saw 96 last year.
Have any disagreements in those 96?
Many of them just get resolved before they reach decision. I don't think that we had any differences in the last year, but there have been. I mean, there have been occasions when you had different results.
If I file with you, I guess that's how it works, right? Is your decision potentially better than their decision? And therefore, I would take your decision versus their. I just don't understand this.
I mean, one other way of
Whether
it
you stop from claiming the victory to take a defeat. This is also novel and exciting. We've never ever heard of a system like this, so we're trying to figure it out.
Really very interesting to people outside of this
Look,
world.
this has been going on for ever since that department got created. And in a way, it's been going on ever since Title VII passed and the EOC got created. Howard's my lawyer. I screwed up. I got fired. Howard says, well, gee, I can file over here. If we win, we're going to get attorney's fees, not just back pay. And for my client's second bite at the apple, I'll go file with the SPB. And it's very rash. And if we lose over here, it's not estoppel or res judicata over there, and vice versa. It's literally two bites at the apple. So there could be a statutory enactment, but that's got nothing to do with this, saying you get one bite at the apple, an election of remedies, etc. And that election of remedies, incidentally, probably wouldn't work vis-a-vis the constitutional mandate. If you're going to take an appeal, my guess is you just have to give that up. But if you go there, you can't. I don't think the statute would make you give that up.
Right. But I think, there is a split of authority in the appellate courts as to res judicata collateral estoppel. It depends on whether or not there was a full evidentiary hearing before the board. This issue, the dual jurisdiction, went up to the Supreme Court. SPB sued DFEA or FEHC years ago, claiming that SPB had the exclusive authority over state employee discrimination complaints. SPB lost. The court said, no, there's dual authority.
Okay, so is this, just help the amateurs here, is this California only, or is this all over the United States?
I mean, this is California specific. I don't know that any other states have our system. They might. I don't know.
I think any place where there's a civil service system and a federal remedy, the plaintiff, the employee, is going to have two bites.
Bites, because this is a state authority, not a federal authority.
Yeah, no, somebody earlier said you could go to DFEH, EEOC, or the SPB, 3 bites. Yep.
Right.
Well,
2 bites are a state authority.
It's actually really 2 bites because we have a work share agreement with the EEOC, and for cases that fall into both jurisdictions, they would either the EEOC or the DFEH would take those cases, and in most cases the DFEH does because state law, the Fair Employment Housing Act, is stronger than Title VII. So that's the reason why we actually do most of the cases in California, and the labor employment law bar it's actually more involved with our department. So in the great scheme of things, I think that the SPB actually hears very few employment discrimination cases brought by state employees, and we hear the vast majority of it. So you're really looking at a very small subset.
And this is
of the
going to make that conflict better.
Yeah.
Because all the ones that are direct filed as discrimination cases don't go to you anymore. They go over here. The only time it comes up is if it's part of disciplinary action. It's ancillary to that disciplinary
right.
action. So
And, this is just
way better.
Just to put it in perspective, this is not a big piece of this consolidation proposal. It was something that we said, hey, this makes sense.
But it's not a big piece, but it highlights, I guess, and maybe we're just looking at it wrong, it highlights a glaring inefficiency that should be corrected.
Exactly.
Just because it's in statute doesn't mean it's correct.
It's not,
right.
It's not in statute. It's in the Constitution.
In the Constitution.
Article 7, Section 3. Review disciplinary actions.
Just because it's in the Constitution doesn't mean that it doesn't necessarily need to be reviewed.
Right.
That's all.
And so we just looked at it and said, hey, let's throw this into, basically.
Any other questions? Any other comments from the panel that you would like to edify us with before we let you go?
I'd like to just add that the DFEH is already conducting monthly webinars on all topics related to employment discrimination, free of charge to all state employees. And we've been doing that for about 9 months, and we plan to continue doing that. So the technology seems to work fine. We go through either GoToMeeting or some kind of AT&T service, and people can just, do it directly on their computer. They don't even need to call in.
You set that up yourself internally?
We set that up. We make that available to all state agencies, and we have a larger and larger turnout every time. And I think it's totally free for everybody. So it does work. The technology is sufficient to do that, and I think this is a kind of service we can continue to offer.
How many IT people do you have?
Oh, I don't have an IT shop anymore. We outsourced it to DGS, Department of General
Okay.
State Department of General
they're doing it,
Services IT, because we're too small a department. We have authority for about 190 some positions, but we currently have about 170 filled positions. And for a small department like that, it's really just much better to outsource and just have greater authority. And we are going to get a cloud-based system. So all of that's going to be working in our favor.
Terrific. Thank you all very much. Appreciate your testimony. We didn't wear you out. Okay, if we could call the next panel, please. Executive Director, Mr. Drown.
To present some perspectives on the state workforce, we have perspective of Margarita Maldonado, who's Vice President of Bargaining for the Service Employees International Union, Local 1000, Brooks Ellison, who is Chief Negotiator for the California Attorneys, Administrative Law Judges, and Hearing Officers in State Employment, and Mike Jimenez, President, California Correctional Peace Officers Association.
Welcome. Thank you for coming. We didn't put you last this time, so.
Thank you.
So we'll start with Ms. Maldonado, then move on to Mr. Whalen, and then we'll go to Mr. Jimenez, and we'll sort of have a good free-flowing discussion here. So you can go ahead and start.
So I'm Margarita Maldonado, and I'm actually a state employee as well. I work for the California Department of Justice, and here representing our 95,000-plus members who work in state service and also who are going to be impacted by this merger. As you can see by our letter, and I'm not going to read the letter because you have the information, but we have taken a general position here, not going either way, because we believe the details are devil in the details, right? And I believe you asked many questions today trying to clarify what the impact will be, not only to the state, but as taxpayers, and trying to ensure we're capturing the savings that we need to capture with this kind of merger. The fact that the merit system is a critical piece with the whole civil service system, we want to ensure that that is maintained. Some of the testimony here, some of the documentation that has been put together outlines how that information or how that process will be preserved. There is a little bit of a conflict, though, in ensuring that the staff that is assigned to do that work does reside under the direction of the State Personnel Board, and that we don't have a conflict with some of the issues being carried over into the department, or what's known now as the Department of Personnel Administration. And so if we can preserve the merit system, it's absolutely important. The other thing is with the staffing reductions that they're looking at making, and it sounds like it's over about a year and a half, 2-year term. We also heard repeatedly today that the departments are both understaffed. And so that does raise some question. If the departments are understaffed, how will they be able to deliver the full complement of their missions if they're looking at reducing the staff?
I think clarity was that Mrs. Ambrose just said that they acknowledge there's a 20% vacancy in their department, but they're getting it done. It's just a little tight.
Well, and they've eliminated some backlog. They've also indicated that. But when you delegate out more of your authority, as they're planning to do out to the departments, then there are some oversight responsibilities that must be maintained.
Well, but I understand that they're just moving people over to the new Cal HR function. That's, I mean, you're saying that they're going to delegate more out to the departments.
Well, the testing,
Okay.
testimony, that was some of the testimony that was given today is some of the testing or the exam development responsibilities will move out. Some of those testing responsibilities will move out. And in that case, you will have to ensure that that staff is trained. And I do understand that they're also being very innovative in delivering some of the training through technology, which is the direction that we're moving into today. So I just want to make sure if they're going to delegate out more, that there is a higher level of responsibility to the workforce and to the citizens of this state to make sure that the appropriate audits are put into place and the appropriate staff are put into place to conduct those audits. So the neutrality, the SPB neutrality issue, it gives an appearance, right, that if you have them both under the same house, then what happens? So more details around how that would look. I know that there was some testimony here also today that spoke to that, and we appreciate trying to make sure those separations do exist and are solid and to protect the rights. One of the other issues, the Ralph C. Dills Act issue that we have outlined here and Mr. Yank brought up, there are ways even in our contracts with the members that we represent, how you can designate positions as confidential positions, and you wouldn't necessarily have to put it into the Constitution. But there are policies that you could enact that would give them the kind of protections that they're looking for. So, and I believe you made mention of that here, and I appreciate that. The other thing, the area around the facilities, it kind of also leads to the same problem around the appearance. What does it look like to have them both there? Physically located, what kind of cost savings are they going to really achieve? The current building, they have some complications because of the age of the building. What kind of hearing rooms are going to be made available to ensure that the merit hearings and appeal hearings are carried out? I think those are some of the logistics, and from what I heard today, it sounds like some of those things will be worked out sooner than later as they work with Department of General Services. So I would just like to, in closing, say that there are still many details out there, and the way that our workforce will be impacted is an obvious concern. And however, overall, we are looking at ways to create efficiencies within the state. And if the reorganization, if this is the tool that we are going to use, and if it does create the savings and creates those efficiencies to save taxpayer dollars, we are in support of doing that. We just want to make sure that the impacts.
Have you been part of the process so far? Have they been talking, the transition team and the implementation team, have they been?
I haven't personally been part of the conversation. I know our organization is in conversation with DPA on a regular basis around issues like this and other similar issues, and it is our intent to continue to maintain that relationship, and I believe we offer valuable service given that most of the people who are impacted do belong to our organization.
Mr. Whalen?
Excuse me, Brooks Ellison, on behalf of the California Attorneys, Administrative Law Judges, and Hearing Officers in State Employment, Bargaining Unit 2. Pat Whalen is the General Counsel, and he's in L.A. at a court appearance today, and I'm sitting in for him. I'm the Chief Negotiator. Appreciate the opportunity to address the Commission. I think generally when we reached out to our members, I think they are supportive of the idea of trying this, good government, trying to be more efficient and more effective. They are somewhat optimistic because we know a lot of the people involved in the process. I mean, we know the governor, we know Mr. Morgenstern, we know Mr. Yank. We've worked with them, and so far they've been pretty good. And I think in part of any proposal, I think that's important, kind of the character of the people that are doing it and what history that you have with them. I think, though, our concern, so that's kind of the good side of it. I think the concern side of it would be when you do this, and there's a lot of enthusiasm, you tend to send a signal that you're going to solve a lot of problems. And I think one of the concerns is when you look at efficiency, you tend to look at budget savings, and those things tend to be a little easier to monitor. In other words, you can have that debate about, where we are in the budget and positions and how we kind of transfer that over, and the Department of Finance can kind of drill down, and at the end of the day you can probably count that up and decide, well, whether or not there were savings. And given where the budget is and we're familiar with that, that's really critical. But I think the other thing that you look for is how effective it is. In other words, are we doing it not just cheaper, but are we doing it better? And I think what Commissioner Shapiro indicated, in other words, you can put all of the wine in one bottle, and that might be efficient, but it might not be the most effective way to do. So we're a little concerned about how that's going to go and how we kind of drill down on that. And I think the senator talked about performance measures. I think we'd like to see some of those things so that we can look back and look at it and say, yeah, not only are we doing it cheaper, but we're actually doing it better. And I guess I would close with one thing that I think we're also concerned about, and that's, well, you can move the boxes around a little bit and you can talk about the number of positions. The one thing that has struck the state's legal professionals, I think more than anything else, is the compensation issue. And not going to debate the whole contract history with the state here, and we are very understanding, because we've been doing this for a long time, of where the budget is. But the state's own salary on the other end of it, in which you're already not making enough to kind of live and pay your bills. I mean, in other words, your spouse who's kind of got you through law school, you've had that whole 3 years or 4 years of deferred, and then you come home and you go, well, gee, we've added up rent and food, and actually we don't make enough money to take the job. You have to look at the issue a little bit different.
As an adjunct law professor at USC, 35% employment coming out of that law school last year. I mean, it's a huge number. Mm-hmm. The number of my students who would like...
one of them is being functioning at all. But I'll go very quickly, and then you can ask me any questions if you'd like. Number one, the plan is somewhat vague regarding the independence of the SPB's appeals division, and raises the concern that SPB appeals could be influenced by institutional independence that's going to remain. And I think that that was something that I was waiting to hear anyway. That assurance had been given as part of this moving forward at the moment than going to SPB, although there's not a substantial number that go to SPB. Number three, the plan appears to eliminate DPA's statutory appeals.
Mr. Manis, we'll follow up on those questions that you raised, because we'll get answers.
Thank you.
If there are answers. And I think we have one more panel today. If you could call our final panel.
Some of these issues have been raised.
Members of the Commission, I'd like to thank you for inviting me to speak today on the reorg plan. My name is LaVon Cohen, and I am the newly appointed Deputy Director of Admin. In my written testimony, I believe the creation of a single department responsible for the personnel management functions is going to be a major improvement for all of us. The current systems, as they currently exist, will increase efficiency and timely responses. We really look forward to the opportunity for clear, concise, timely policy direction from a single control agency. It's very exciting to us. We see as some of the positives consolidated approach to CEA allocation approval and level assignments. Right now we have to bounce between both departments. One approves the CEA, one approves the level. Sometimes one doesn't do until the other does, and so it takes a long time. We're looking forward to a single entity for the establishment or modification to our classes, as was addressed hungry for single, clear, updated, written directions from a single control agency. There are so many laws and rules out there, and even as someone who's been dealing it was mentioned earlier, we do need to ensure that CalHR has adequate resources. We are often forced to wait months now for decisions from either SPB or DPA. And I qualify that with, I told my DPA and SBB partners none of this was personal, but I do want to bring out some of the downside. We see the elimination of the redundancy and the additional delegated authority that's going to go out to line programs as one of the key components for the success of CalHR. However, we do recognize that the increased delegation also comes with increased responsibility and increased accountability for us. As was mentioned earlier, for our department, we have had absolutely phenomenal success with that. We've brought them in. There are very strict requirements for doing their probation performer with the hundreds that we've hired. And I think my colleagues would probably agree in other departments. Really happy with that.
How do people know about that? How do they?
It's online on the SPB webpage, and I can say they've worked, I think, very diligently over the last several years to modernize their webpage, make it easier for folks on the street to, just click on there and find open exams. And as I think Susie mentioned, it's 24/7. It's real time. You take the exam, and by the time you click the final button, you get your score, and you can then immediately start applying for state jobs. The other thing that it's done for us is oftentimes people will know of someone on the outside who might be interested in state service. They can actually bring them in, talk to them about the job, do an informal interview with them, and say, hey, listen, go out to that website, take that exam, get your results, and then they can, start the regular process of recruiting and bring them in that way as well. So it's been phenomenal.
Well, then what is the concern if it's been such a phenomenal success and you've had excellent candidates? What's the concern with 12,500 that are going to retire over 5 years?
Oh, my concern, I just hadn't got to that point
yet.
Oh,
okay.
With the merger, HR Mod is being folded into the merger of the new departments, and I just can't emphasize enough that we have to keep this focus. We've made huge strides, but we still have additional classes that need to be moved into that same venue where they're 24/7. I don't want...
Autonomy do you have there now?
We have quite a bit. Our department enjoys some pretty flexible delegated authority. I believe over the years, and again, I've been there for 23, I have a very strong relationship with both DPA and SPB. We have proven that we have been worthy of the delegated
You've
authority.
been through an audit, one of their audits?
Not in a while. But we work pretty closely with them, and because we have worked so well with them on the selection side at SPB and also with our partners at DPA, I think they have a confidence in us, and we have not let them down.
Mm-hmm. Okay.
And so I think just in closing, I want to say we appreciate the fact that the reorg plan does provide for the user group to be developed and staffed with HR experts in the line program agencies. I think we will partner with the DPA SPB implementation team and create a new and dynamic CalHR, and that having this feature will allow the department staff to participate and actively contribute to the success of the reorganization.
Thank you. Ms. Campbell?
Hi, thank you. Yes, my name is Tina Campbell, and I'm currently the Chief of Human Resources with the Employment Development Department. And I'm here today just to talk about the customer perspective. We consider SPB and DPA a partner, but we also consider ourselves a customer to them. And much of what Levon said, if not everything, I totally agree with from the HR perspective. I also want to talk a little bit about what we still expect from both SPB and DPA once they are combined, and then some maybe bigger picture that has been addressed but will be more clearly defined as this merger goes forward. And we still expect both SPB and DPA, the new CalHR, that they would obviously eliminate duplicate efforts and still provide broader learning opportunities for its staff, and also provide a one-stop shop for its customers. I think that's one of the underlying things that the HR perspective that we look at is one place to go to rather than two, and getting conflicting information. We still expect them to work on the issues with classification and pay. We also hope that the appeal and merit process, that it is quicker than it has been in the past. We do see a lot of stagnant cases, although, as has been testified here today, they have been moving quicker on those. One of the things that I don't know that's been addressed enough today is the training of our own staff, and generally speaking, training is the first thing to be cut under tough budget times. And like any organization, if you go out there and you look at private organizations, the amount of money that they spend on training, I think our department spend 1% on training. Other departments, and I know that we do, are confined by our budgets, but that, I believe, is one of the underlying problems of state government, is that we don't spend enough time or effort in that area in training. And so I would be hopeful that we have a bigger emphasis on training under the merger. And also, one of the things that we, obviously by nature, State Personnel Board and DPA are called control agencies, and that's pretty much how we view them. We would like them to be service agencies more than control. And we understand there's regulations and there might be some legislation that needs to be changed. But there are a lot of higher level executives making decisions in their departments, and we would just like more service rather than just oversight and control. So we're hoping for that in the merger. We touched on performance management. Again, I think that's absolutely necessary in state government. Other states are doing it. Federal government's doing it. City, county, private industry does it. And I know that California is moving in that direction, and I would just like to see a bigger effort in that area. And we can do that, obviously, through the California Performance or Performance Management Council that we have now. Many of our state entities, the directors, are already involved in that effort. And so I think SPB DPA merger can look to them for guidance. And again, also outside of state of California, there's wonderful models out there that are already in existence, have been doing these type of mergers and being very efficient at it. I understand cost is what we're looking at, but I do hope what we really gain out of this is bringing state government back into the forefront with our best and brightest, and bringing some of that credibility back to state government.
Let me ask both of you a question, sort of about the way you function at your level and how that relates to either the DPA or the board. Hypothetically, you've got, let's take a classification system. You've got a classification system, and the classification's just not working for the types of people that you want to get. Or you need a new classification system. Or the pay scale you got for your classification isn't allowing you to recruit the people that you need to fill these jobs. What do you do, and how long does it take to fix that, remedy that?
I can give you actually a great example. We had a situation in healthcare services where we need to use an assistant division chief. We feel that that's a level we need in our department. We don't have a classification that addresses that. However, a couple of other departments do. And so about a year or so ago, we reached out, and we would first go to DPA to start that process. Reached out, consulted with them, told them what our needs were, did some exploring with some of the other departments. DPA came back to us at that point and said, well, we don't want to let you use the other department's class. We're not really in a mode of creating any new classes now, so we think you should possibly create CEAs, that might be the appropriate alternative for this assistant that you want. Our partners at SPB, however, have a system in place by where they only allocate CEAs down to a certain organizational level, and this assistant was at a level that's below where SPB wants you to use CEAs. So we were basically just left with no solution. And so that's one of the things that I'm really hoping this unified department will fix. We'll be able to go to one spot, start our work on a classification, be it the revision or a new classification, and work through the entire process, start to finish, with one group of staff who are experts. And the folks in both departments are experts, but they both come from different views, and so we get kind of stuck in the middle.
What'd you say about them, Ms. Campbell?
I will talk about the CEA because that's what I have mostly experience with, and I would say at a bare minimum, it takes at least 4 months to go through that process to create a new CEA, and close to a year on some of the other ones. Part of that is the department has responsibility, obviously, for the information that they put forward. I think the thing that's been really hard from an HR perspective is, it's bring me a rock. Well, not that color. Well, we need one with spots on it. It's not clearly defined what they want, what they're looking for in a CEA.
But why don't they let you tell them what you need in a CEA? I mean, that to me seems like the more appropriate.
Right, and that's the general idea. We write, it's a new allocation, used to be referred to as a KPD, key position description. We do write that. And then between the two entities, they decide whether or not it clearly is a CEA or not. And, as Levon spoke to, you can't necessarily get a new classification forward, and the CEA seems the most appropriate, especially when you're looking for a position to give.
That's kind of a catch-all, though, isn't it? The CEA position. I mean, it's not. No. Oh, okay. Seems like it, the way it's described.
Yeah. No, the CEA. Obviously, the primary driver of the CEA is policy, and we do emphasize heavily when we do write our new position allocations on what the policy is. I think it gets muddied because, well, the secretary has a policy and the director has a policy and that person and that, and so how is this person, is it new policy? And when you look at organizations and the different responsibilities they have, again, it is up to the departments to define what that is, and then SPB and DPA to come to some agreement on whether or not it meets that allocation. But I think the original question was how long, too long, does the process take?
And how about on pay?
That's a tough one. In this economy and the one that we've been dealing with for the past several years, there hasn't been much we've been able to do with pay. We work with DPA, and they do everything they can for us through the negotiation process, where we've identified that we have, serious problems with classes. In some cases, we're able to get some special pay differentials when we can demonstrate that there's clearly a recruitment and retention problem. But with the limited funding, that's been pretty minuscule in what we've had to deal with over the last few years. They've just kind of been tabled for now.
And Commissioner Ellis had a question.
The previous speakers didn't quantify this, but they estimate that ultimately some of the major savings will be at the department level when this reorganization goes through. Do you agree with that? Do you see where you will have savings as a result of this?
I think for me, it's premature to know that. I think some of that will bear out when we see what the new organization does. And where they have some efficiencies and are able to maybe take on some of the work that we're currently doing, I think it's possible. But I don't really feel as though I can give you a good answer on that at this point. I think it's too soon to know.
Ms. Campbell, do you have an idea on that?
I have an opinion.
Yeah, good. We're good on opinions here.
Okay. We have too many classifications, and we have too many exams, and we do need to, in HR Mod, we spoke of that, and I can't speak any highly more than Levon did of their efforts, and I hope they continue to go in the direction they're going, but we need to tighten that up. We have too many, which means we have more employees that have to look at all the different elements to administer the exams and all of that. So,
where should the leadership come from on those issues?
Well, I would still go back to under the new Cal HR. That would be they still have that role. But
so we should be looking to them to.
And they are doing it. The HR Mod has already, as Levon said, combined some of those classifications, eliminated some of those classifications. So if we continue, and I would say in fast pace, like Levon said, we talked about the baby boomers going out. If we can continue that, we could bring enough in. Where we're going to really have the problem is going to be the transfer of knowledge, because as we all know, state government is a very complicated political environment, and we still need to have folks that have been around to be able to provide some historical perspective on state government.
Vicki?
Well, part of the issue also is the length of time it takes, is overlap with some, finance policies. Like if you leave a position open for 6 months, it goes away. So you're trying to fill that position with something that hasn't gotten approval yet, so you're jiggling it around to make sure you don't lose it in the interim, and all that takes people and time.
Yeah. Mr. Callahan, you want to weigh in on this discussion?
Sure. I know I'm at the end, but I'll add at least two pieces that really haven't been discussed at all today. I thank the chairman. I thank the commission for the opportunity to come and speak about this. I've been in and around state government in California now for 13 years at USC, working with a number of state agencies and departments and drawing on that experience and also the research that I've seen on organizations. I mean, the commission cares deeply about organizational performance. What we know from looking at organizations, public sector, private sector, over the last 20 years is organizational structure doesn't drive organizational performance. Organizational culture drives organizational performance. There's really not a discussion in the report or a discussion till now of how to get at high-performing organizational culture in trying to drive organizational performance. The other piece that we know from research and you know from looking at public agencies that do well is the importance of strategy. In the absence of effective strategy, and I'm not talking about long drawn-out, consultant-driven, expensive, strategic planning. When I was directing the California Leadership Institute and you would mention the word strategic planning to state executives, their eyes would roll in the back of their head like they were auditioning for The Exorcist. because it was just such a difficult, trying experience. I'm really talking about the development of strategy in real time. What does success look like? And so in the discussions and in the report, there's pieces of that discussion, what success looks like. Some of it focuses primarily on the budget, but there's really not a clearly articulated strategy discussion. And so in the research on the private sector that Jim Collins does, he finds that it's not just the metrics that you choose, but it's the discussion of that metric, of those metrics, that 2 or 3 year discussion, oftentimes in the private sector, that discussion is as important as what is chosen. So in the absence of discussion on strategy, how to develop a high-performing culture, in absence of, and on both strategy and on culture, getting at the performance questions that you want to get at will be difficult. There are models in state government, and the models deal with this, and Tina referred to them very nicely. I mean, I've seen successes, particularly around performance management. And the Performance Management Council that the Little Hoover Commission was a catalyst for setting up over the past year or so, and seeing the work to set that up, has really gotten at the question of organizational culture, because it gets at the question of conversations about performance and accountability. So at the core of the idea of merit-based selection is that in California, we are all advantaged by merit-based selection because it is both a respect of the principle of rule of law, but it also gets us better people in state government that can deliver better outcomes for all of us in state government. So the idea of performance-based management really supports and advances merit-based selection. And you have examples, the acting director in the Department of Toxic Substance Control and the work that was done there really looked to move from discussions of what we're doing to what outcomes do we want to generate and how will we measure them for the state of California? How will we know? What does success look like for our department? The Performance Measurement Council has not only talked about that, but it's brought examples together that are shared across state agencies and state departments. The very problem that the Little Hoover Commission addressed or identified in the late 1990s in one of the reports, and the constant term of state government is silo, silo, silo. This Performance Measurement Council gets exactly at that problem and gets at what we would call in the research organizational learning. So there are examples outside of state government, the Center for the IBM Center for the Business of Government, John Kaminsky. They've really pushed this idea of drawing on the experience of GIPRA and drawing on their work. John's out of the U.S. General Accountability Office, drawing on that experience to get real examples and how you operationalize those examples of performance management that matters. So the piece that I'd also emphasize in terms of the most familiar piece I'm familiar with HR Mod is the training piece. And I've been impressed with their commitment to that, because the dynamic in state government can be, I've learned my job from someone who learned it 10 years ago. And they learned that job from someone who learned it 10 years before that. And they learned it from someone who taught it to them in the 1970s or 1960s. Well, that's not how you get at high-performing state agencies. And it actually locks us into the past. Institutional and historical knowledge is important, but a lot's been learned since the 1960s. And I was talking to somebody a few years ago from a state agency, and they said, well, we tried that, and this was before the current election. They said, we tried that during the Brown administration. And I jokingly said, oh, well, at least it wasn't the Pat Brown administration. And then I did the math. And the math was they had talked about something 25 years ago, and so they were unwilling to talk about it in 2007. That's being locked into the past. And so I believe in being informed by the past but not being trapped by the past. And there are people who have worked through that in the performance management work, Denzel Verardo and Parks and Rec, and then over Department of Toxic Substance Control. You have the Performance Management Council that's looking at that. And I'd urge this commission, as you move forward with this consideration of the organizational structure, that organizational restructuring, and one of the commissioners mentioned this, you see this in business all the time. Well, we're going to merge, and the merger doesn't take. It doesn't produce the profits. It doesn't, well, because there's way more to it than moving the boxes. And the way more to it that we know from research and I know from working with state agencies is the importance of organizational culture, the importance of strategy, and then how do you get at performance management.
So is that something that this new HR agency does, or is this organically created out of these departments that we've heard from today?
Well,
and
the
other
new
places?
HR department does it if it wants to be successful.
Yeah, we often debate here, you kind of raised it. It says, do I want great leadership or do I want great structure? Well, ideally I want both great leadership and great structure. If I can only have one, I'm going to take leadership every time.
Well, I mean, for me, the one-sentence definition of leadership is leaders create new possibilities. And so if the possibility you want to create is high-performing state government that brings people in from the outside, that supports the people who are in there, the HR mod investment in training, I mean, we in the public sector, we don't make that investment outside of the federal government with the Federal Executive Institute and outside the military. And they make that investment. General David Petraeus, he's the product of a 30-year investment in developing his leadership since he was 18 years old. General Peter Shirilli, we recognize the importance of that investment when the stakes are life and death. Often in California, these are very significant stakes in each of the state agencies, and they deserve that type of investment in developing the best leadership that can be developed.
Commissioner Schwartz had a question?
I really appreciate your comment, and I think I wrote down exactly what you said, which is organizational structure does not drive organizational performance. In your opinion, does this reorganization in any way potentially or actually going to affect performance?
In the absence of accounting for organizational culture and the absence of structure, you leave it to chance or to the good fortune of good leadership. And my suggestions are, rather than leaving it to chance, cause it by design. Have great leaders live in a design world, not a world where they throw ideas on the wall and hope they stick. And so design through strategy, design through ways of getting at improved, high-performing organizational culture, and then you'll get there by design as opposed to Herculean efforts or different good fortune that falls your way.
Right, but that's not what was done here was, and you've read the reorganization plan, they were talking about moving boxes around and shifting responsibilities, not about improving performance or culture.
Well, it can be a start for something if you add in the org culture piece and the strategy piece.
Sounds like a good recommendation for the Hoover Commission to make.
Yeah.
However,
like ones we've made twice before, I think.
Yeah.
Just two quick follow-up questions, and these are more specific. So under and maybe this panel isn't best equipped to answer it, but I'll give it a shot.
I got one rule. Ask me the easy questions, ask Tina the difficult ones.
Well, here's the question. So it's anticipated through this and other reorganizations that there will be a reduction in force of employees, perhaps a very significant. Under the current structure, we have to give credit to seniority. And the decision as to seniority are often complicated decisions because employees can be in different places and their crediting for the seniority may vary. But someone has to make the call who's in line, right?
Correct.
That call was made by the State Personnel Board?
No, DPA.
DPA, forgive me. Who's going to make that call into this consolidation, and will that department have enough resources to be able to manage that anticipated mini tsunami of layoff folks who want to get back in a new job?
I think it would be Cal HR, I believe from the proposal, would maintain that seniority function that DPA has.
Do they have the resources, and as you understand the reorganization, to keep up with the expected large number of RIFT employees so that they can be put in a queue in a way that doesn't require them to wait 6, 8, 10 months before they figure out where they are in the pecking order?
Well, I'm not sure that I can speak to what resources they have now or what they have planned. I believe they are anticipating the large number of staffing reductions that may be coming in the months that are ahead, and I do think they're planning for that, but I don't know the specifics of what type of maybe staff redirections they're anticipating.
Just to the question of culture and thinking about possibilities, and correct me if I'm wrong. Let's hypothetically say we have an opening at the Little Hoover Commission. We have to find a job classification that fits the description of the job, and we set minimum qualifications for that job, right? Correct? And then we put out a notice saying we're looking to hire a program manager with these minimum qualifications. Is it true that the director of the commission and perhaps someone from the Department of Personnel has to sit in on every one of these interviews for every candidate that meets even barely the minimum requirements, minimum qualifications?
No.
How much latitude does the personnel, does the director or the hiring person have to, if you will, skim down or narrow down from all the people who met the minimum qualifications in order to let them come in and take the test?
That's completely delegated to the departments. I mean, we don't have DPA. Once the specification is set, once the job announcement is out there, it's up to the department to then go through the rest of the selection process and recruitment, if I'm understanding your question.
So in other words, our executive director isn't under an obligation to interview or test every person who comes through the door having met the minimum qualifications?
Well, I think there's a difference between interview and test. I mean,
Okay.
for us,
Fair enough.
we're running an exam, everyone who meets the MQs is allowed to take the exam. From that, a list of successful candidates is developed. At that point, that's when departments have the delegation to develop screening criteria. We work in our department, we work very closely with our Office of Civil Rights to ensure that screening criteria is, doesn't disadvantage any one group. It has to be based on the job. You can narrow it down. If I were the hiring manager, I could delegate to my subordinate manager to do the interviews of those who meet the screening criteria and maybe select one or two candidates that I would interview, or perhaps they just make the choice all on their own and hire.
But does everyone have to be screened who meets the MQs?
That applies.
Everyone who applies,
Right.
you should screen them to determine whether they're going to be interviewed or not.
Yes, every one of them has to be screened.
Right. And I'm guessing that puts a tremendous burden on the individuals who are charged with doing the screening and later the interviewing, right? So in terms of a cultural fix, a change that might make more sense, because I'm guessing that acts as a real discouragement in terms of broadening the net by going external, because you may have an overwhelming number of people who meet the MQs, and now you got to screen every one of them, right? So we're sort of in that box where a tremendous amount of energy and time is going to be developed to do these screening interviews, even though you may.
It's a paper screen. I'm sorry. I need to clarify that. It's a paper screen. They do not have to speak to every one of them. They can review their app against screening criteria, get to a much smaller number that they bring in for interview.
Commissioner Schwartz, if I can make 2 points to your question about whether or not this is going to be more burdensome, or are they going to have enough resources in the new CalHR? A lot of the department is involved in a lot of the process on the layoff plan, so it's not all, the burden doesn't lie completely with the new CalHR as far as the layoff plan, so the departments go through that and calculate scores and all of that and work in conjunction with CalHR on that. One of the other questions or statements that you made was whether or not they would have enough resources. And I think that is a question that needs to be taken very seriously, because many of us believe that they don't have enough resources now for some of the functions that they provide. However, if a performance management system is put in place and we start looking at processes, we would hope to gain efficiencies through our processes, not just letting go of people or eliminating positions. And that's where a lot of our time and money is spent, is in processes, not just with how many people it takes to do it. And if we can speed things up and move things faster and reallocate our resources, I think, that would answer the question, how many resources are they going to need to do that? But you have to put those measures or metrics in place to find that out. You're welcome.
Any other questions from the Commission? Any other comments that you'd like to leave us with in parting? Thank you so much for coming up. We appreciate it. Yeah. So I have one request from the public to speak. I'd ask you to limit your comments to 5 minutes. Mr. Gerald James. Mr. James, you come forward, address the commission. Welcome. Thank you for sitting through our hearing.
Thank you. I will certainly not take the full 5 minutes, but I appreciate it.
Good.
Gerald James. I'm General Counsel for the Professional Engineers in California Government and the California Association of Professional Scientists. We represent 13,000 state professional engineers and related folks and 3,000 state scientists. I want to say that with this proposal, we want to ensure that the State Personnel Board, President Tom and her colleagues, have the autonomy and the resources to continue to enforce the constitutional mandate that the people voted in 1934. So having the board reporting in some different fashion, as long as they have the staff and the autonomy to continue to do the functions to administer the state civil service system, the constitutional merit-based aspect of that, then it looks like this proposal has momentum and is going to go forward. Previous proposals, the Governor Brown's first proposal in 1980 to create the Department of Personnel Administration didn't move these functions over. Governor Duke Majan had a reorganization plan that moved some functions over to DPA, but didn't move the functions that are contemplated here. The State Personnel Board goes beyond just discipline in administering the constitutional-based civil service system, the merit-based system. And they ensure that positions in state government are folks are selected for those through competitive means. So often what will happen is a department will say, well, we are going to run a test, and that test to select these candidates is going to result in everybody passing the test, and then we'll go ahead and just pick a candidate from that pool of folks who passed the test. Well, we need someplace to go when departments run amok like that, because a competitive testing system for selection can't allow everybody who runs the race to be the winner of the race. So we take those items to the Personnel Board. Other items we take, you heard about career executive assignments. Many departments say, well, we want all of our folks to be CEAs, because then we can pick the people we want without the burdens of the regular civil service selection system. Well, not every position should be a CEA. These are exemptions to the regular civil service system. The criteria are in place. They were put in place by the legislature, and they were put in place to conform with the civil service system that the people voted in 1934. So we take those challenges, if you will, to the Personnel Board and say the departments are not, this position, while they might do important work and you value your work, and sometimes it's the work of our members, we're not going to say that the work they do isn't important. We want to say that it doesn't rise to the level of being an exemption to the merit-based civil service system. And so the Personnel Board will rule on those, and we need to continue to ensure that even though they're part of this structure, they have the autonomy to do that. Another item is personal services contracts. The Personnel Board has jurisdiction to review proposed outsourcing of work to see whether it either is a cost savings or another exemption from the civil service mandate that state employees should do the work of the state. You heard Director Yank talk about the Bay Bridge and drilling the piles. That's true that that's an exemption to the regular mandate of the regular type of work that typical state employees perform on a regular basis. But the civil service mandate includes reviewing those contracts, and that's part of what the Personnel Board does currently, and we want to ensure that they still have the staff and the ability to effectively do so. So not just a 5-member board sitting by themselves, but as Ms. Ambrose alluded to, the policy unit and the other structure and support to ensure that they're able to effectively get their job done.
Okay. Any questions? Thank you for coming. Appreciate it. Okay, I have no other requests, so with that I will adjourn the public hearing. We're going to reconvene in about 15 minutes in room 340 of the Library and Courts building for our business meeting, which is a open meeting.
You mean our normal spot?
No. Room 340, Library and Courts. It's on N Street. N Street.
There. We'll walk you over there.
No, it's not there. Is it there?
What is it, 347 in?